Derek Chauvin, day 14, trial continued on with the government presenting its case in chief. We heard from more witnesses today. Let's take a look at a bunch of different clips today. We're going to be looking at a lot of different witnesses as well as some cross-examination that was taking place from Derek Chauvin's attorney, Eric Nelson. Before we dive into the clips, I want to give a quick overview of what the trial board looks like, because today we have a new addition. So this woman is another prosecutor who joined the team today, and she was really handling the line of questioning for the minors, for people who are under the age of 18 at the time. We'll notice that we have two people in our clips who were under the age of 18 at the time this happened back in May 2020. And so now they're over the age of 18, but the court is still sort of protecting their identity. We don't see much of them. And they brought in a special prosecutor, somebody to go and ask questions of these two individuals. And so presumably, I don't know much background about this woman, but I would guess that she is somebody who deals with juveniles, somebody who, has experience working with adolescents. And so they brought her in specifically to ask questions about or of those two witnesses. And so we're going to start off today. I think I have four, maybe five different witnesses that we're going to go through, shorter clips, about 1 to 2 minutes. And I tried to balance this thing out a little bit. I didn't want it to be all clips of the government doing direct examinations of their own witnesses. So let me frame this out just a little bit. Right now, the government is presenting their case in chief. So it's their witnesses. They get to call their witnesses, put them on the stand, and do a direct examination from them, which is a very open-ended sort of line of questioning. Just, hey, where were you? What happened next? What happened next? How did you feel? What did you see? What did you think? Okay. And so it's very broad and open-ended. And so you're going to see a lot of really kind of, if you're somebody who is, I would say, empathetic to Chauvin, or you're somebody who is on the defense side of the aisle, you're going to watch a lot of this and you're going to be feeling like, oh man, this is just totally unfair. They're just slam dunking him as this entire thing is unfolding before us. Well, yeah, they are. And that's kind of the point of it. It's the government's case in chief. This is their turn to go. And the defense gets the opportunity to cross-examine the government's witness. Now, as soon as the government's done with their case, then the defense gets to call their witnesses. And so if you are on the pro-George Floyd side, when that happens, you're going to be sitting there going, this is ridiculous. All these defense witnesses are just coming out here and supporting Derek Chauvin. They're not giving any, inquiry as to how people were feeling or what happened to Floyd or all of that. And so this is just natural. People are going to watch one side and they're going to feel like it's very biased one direction, because it is. It's kind of the nature of the proceedings. The government goes first. The defense gets to cross-examine them. The defense gets to go next. The government gets to cross-examine their witnesses. And it's the adversarial process playing out. And so as I'm watching this trial, I'm trying to take clips in a way that I feel is sort of balanced, more or less. Hard to do that right now because these are the government's witness. And, they are the people who are asking the questions. And a lot of this testimony is in the government's favor. And it should be. If they call a witness and it doesn't support their case, that was a garbage witness. They shouldn't have called that person. So you can expect that just naturally that a lot of this is going to be in favor of the government. But I tried to sort of balance the scales as best I can with some cross-examination from Eric Nelson, Derek Chauvin's defense lawyer. So then he comes out, he gets to cross-examine him, and there's a back and forth kind of going both directions. So I'm trying to play it fair. I'm trying to provide context. Of course, if you want to watch the whole thing, go do that. You can watch it at 2 speed and get through it relatively quickly because they do take a lot of breaks. But we're just taking clips here and there. And, I'm sure somebody somewhere is going to be mad that I took something out of context, but that's just the nature of doing a show like this. So this is the first clip from Donald Williams. We heard about him yesterday, and he was testifying yesterday, but they didn't finish. So today he got called back early this morning, and Eric Nelson was going through the line of questioning with him. And he starts off by sort of expanding the context. We talked about this yesterday. The government really wants to narrow the scope of this thing. Just really kind of hone it in there, make a nice little circle so you can see them right through that. And that's the 8 minutes and 46 seconds, or the 9 minutes they sort of expanded it out to. They want you to just be really focused on that. The defense, they want to expand that. They want to take that and just really blow it up and include everything, including a 2019 prior, including the 15 minutes before They sort of had interactions with George Floyd, including the sort of fleshing out the timeline about other things that were happening there. And so it's not only about the 8 minutes and 46 seconds. I mean, they just kind of want you to be narrowed down on the video, even not so much about the conversations. Maybe the police did call the paramedics early, right away. Maybe they did. And so what Eric Nelson's trying to do is just expand that scope and say, well, look, Mr. Williams, when you were there, you sort of testified that you saw all this stuff and you would have interpreted the situation differently based on what you saw, but you didn't see everything, right? You weren't there as this entire case was unfolding. You sort of came in out of context. You sort of, inserted yourself into the middle of a whole situation that was unfolding, and you're trying to make judgments based on what you saw there without taking into consideration the rest of the context of the incident. So this is what Eric Nelson is getting into, and we're going to take a look at Mr. Williams, and we'll see how he is handling this. So once again, this is the defense cross-examining the government's witness. This is the government's witness. They called him. They thought this was going to be a good witness, and he's getting to ask questions. And I want you to notice this, right? We're going to see this as a theme throughout. When we are dealing with cross-examination, just watch how rigid these witnesses are. They know what guys are the good guys and the bad guys. When the prosecuting attorney comes out, they're, hey, buddy, how are you? It's great. Yeah, that's exactly what happened. And they just, it's very jovial. Then the defense comes out and they just go, oh, no, that's not what happened. Okay, yes, that's what happened. And they're just jacked up and they're ready to they're kind of spring loaded. And it's just natural. It's just what we do as human beings. So I'm not trying to be critical of these people. This is just how it goes, right? Everybody is going to respond this way when somebody is cross-examining you. And so as we go through this, let's keep this in mind, right? These are people. These are not professional lawyers. These are not professional witnesses. These are not people who did not avail themselves of this situation. These were all people in a very bad place at a very bad time. Everybody who is involved in this case went through something traumatic, whether you think that Chauvin was the cause of Floyd's death is kind of irrelevant. Everybody who was there went through something traumatic because somebody died. Whether it was an overdose or whether it was asphyxiation, it doesn't really matter for this conversation. Right now, what we're talking about is just having some empathy, having a little bit of humanity for all of these people. I'm already seeing on Twitter, people are starting to try to spike the ball with these witnesses, right? And these are just everyday people walking to the grocery store, living their lives, and a tragedy unfolds right before them. And so, we can have a little bit of humanity, just recognize that some of these people, the emotions are high around the whole world about this case, and we're not even involved in it. I mean, think about some of the stuff we talk about on this channel. We're not even involved in the case. We're just observers monitoring things from an outside perspective. These are people living it. So we're going to hear some tears. We're going to see some anger. We're going to see when we get to Genevieve that she gets scolded a little bit, because of that. People's emotions are so high. And they're just trying to do their best. Truly, I believe that they're all trying to do their best. They're trying to participate in this idea of justice that we have. And so let's just keep this as civil as we can, just as observers and commentators as we go through, not just today, but this entire case. All right, so here is Mr. Williams, and as I mentioned, Eric Nelson is trying to flesh out the scope.
You can see that?
Yeah, correct.
This was already admitted into evidence yesterday. You would agree that Exhibit 18 shows you walking along 38th Street on May 25th, 2020 at 8:23 and 12 seconds.
Correct.
Okay. So, I'm not trying to trick you, all right?
Yeah, that's fine.
All right. And it's fair to say that prior to your arrival there, you had no idea what had been going on in the area.
No, not at all. Like I said, I just seen squad cars and didn't know what was going on.
Right. And you testified that as you kind of came around the corner, your energy sort of pulled you towards that incident, right?
Yeah, that's totally correct.
So you would have absolutely no idea that an ambulance was called 3 minutes before you arrived.
Don't know anything about that.
You would have had no idea that an ambulance was stepped up to code 3, which means get here quick, 2 minutes before you arrived.
No recollections of any of that.
You weren't there, you wouldn't possibly know, right?
Wouldn't know at all.
You testified that kind of based on your experience as a security guard, your first inclination is to just sort of observe everything that's going on, right?
Totally correct.
And that's what you did.
That's why I felt like I did correct.
So it's fair to say that you had not observed any prior contact between the Minneapolis Police Department and Mr. Floyd.
Only what I seen.
You would have no idea that they had been dealing with him for 15 minutes prior to your arrival.
Objection, Your Honor.
Not mine.
No, right?
He can still answer her question?
You can still answer it.
Oh,
Would you like me to state it again?
repeat that question.
Sure. You were not aware that the police had been dealing with Mr. Floyd for 15 minutes prior to your arrival.
Not at all.
All right. And so this may seem very minor, like very much minutia, but this is what the defense attorney is trying to do. He's trying to sort of lay out a theme here. We're going to hear a lot of opinions from a lot of people as this continues forward. We're going to hear that as we go throughout the day, right? A lot of opinions, a lot of people sort of just getting into the project when it's kind of, already started or halfway over, and then they want their input about what should have happened, right? You remember those kids from school? They would just kind of insert themselves into the conversation. Hey, what the hell? You don't even know what we're talking about here, okay? This is our business. You don't get to come in here and insert yourself and tell us how to change course and do all of this stuff. And it's kind of what Eric Nelson's trying to do here, saying, listen, yes, you're a security guard. You are a mixed martial artist. You've got some experience. They spent a lot of time talking about different chokes, air choke, blood chokes, whether you can do it. They talked about a lot of the wrestling moves and full Nelsons and all this stuff. Okay. The point here is your perspective is lacking. It's not filled. It's not full. It's just a small window from a much bigger story. And that's what Nelson's trying to do here. Say, yeah, okay, all of your opinions, thank you for those. Those are great, probably valid opinions, who knows. But the point is, you didn't see most of what happened here. And so what you're trying to essentially do here is pass judgment on a situation that you know nothing about. And really, it's a credibility type of an argument. And you're going to see here that Nelson is doing this sort of repeatedly. Government's trying to narrow the focus. Nelson's trying to expand it back out. And this line of questioning, I think, is effective. It's asking the jury to think about the scope of the opinions or the range of the opinions. What can they reasonably opine about? Can they opine about a situation where they weren't there? They didn't see anything that happened that led to the situation? Maybe they could, but maybe they can't. And that's what we're talking about when we get to reasonable doubt. Now, we've got one more clip from this gentleman, and this one gets a little bit heated, and not really on his perspective, but I want to just point out a couple things here. Number one, there is a profanity warning. Not from this gentleman, but from Eric Nelson. And what Eric Nelson's doing is referring to his video that he took as a bystander, or that he was captured on as a bystander, where he's using profanity towards Chauvin and the other officers, basically saying, you're a punk, you're a whatever. And there is profanity here, and Eric Nelson is the one who actually uses it. And you're going to see sort of this tension that exists from people who are being cross-examined. It doesn't matter if it's a government witness or a defense witness. People just get this natural tension. So when anytime somebody's asking them a question, they become defensive to the point where they're almost non-responsive, and they have to double down on their answers. And so you're going to see here, what Nelson is doing is he's having a conversation with Mr. Williams, and he's saying, well, weren't you angry when you saw all of this? And he said, no, I wasn't angry at all. I was being professional, and I was keeping my composure, something to that effect. And he goes, okay, but you were screaming at him, you were yelling profanities at him, and, doesn't that sort of indicate a tendency towards anger? No, it wasn't. And you're going to watch him as he's going through this. This witness is sort of mean mugging Derek Chauvin in between questions. So Eric Nelson says, isn't it, basically you called him a punk, right? You called him a B, you called him whatever. And he goes, that's right. And he mean mugs him. He looks right at Chauvin. That's right. I did that. That's right. I said that also. And I said that also. You are, kind of a thing. And that's not something that I think plays well for the jury. Let's see what you think before I start to opine on it. Let's hear what Mr. Williams had to say, and you can watch this for yourself. So here he is in court today.
Again, you made a statement to Agents Garvey and Eckert.
He's looking for the quote right now.
And in that statement, you said,
Your Honor, I'm going to
form of cross-examination.
Overruled.
Prosecutor objected, doesn't like the questions.
In
Judge
that
just
statement, you
overruled.
said, like, I really wanted to beat the shit out of the police officers. You said that.
Yeah, I did. That's what I felt.
You were angry.
No, you can't paint me out as angry. I was in a position where I had to be controlled, of control professionalism. I wasn't angry because I stayed
You
on the
object
curb.
as non-responsive.
Overruled. Overruled.
Answer will stand.
Next question.
Thank you. You started calling them names. Yes?
Yeah, you heard that. Yeah, you heard the
Right?
video.
You call him a tough guy, right?
You watched the video.
You call him a real man, right?
You watched the video.
You do have to answer the question yes or no based
See?
on what he's asking.
I'm going to ask you that again, so your answers should be yes or no, okay?
Yes,
You called him a tough guy.
I did.
You called him a real man.
I did.
You called him such a man.
I did.
You called him bogus.
I did.
You called him a bum at least 13 times.
That's what you counted in the video,
That's what I counted.
and that's what you got. 13.
And that was early on, right? Those terms grew more and more angry. Would you agree with that?
They grew more and more pleading for life.
All right. After you called him a bum 13 times, you called him a fucking bum.
That's what you heard?
Did you say that?
Is that what you heard?
I'm asking you, sir.
I'm pretty
Did
sure
you
I
say
did.
that?
You heard that. I'm pretty sure you did.
You call him a fucking pussy ass bitch.
If that's what you heard, I'm sure that's
I'm
what I did.
asking you, did you say that?
If that's what the video recalled, that's what I did.
You called him a bitch.
If that's the video you heard from the video,
It's
that's
a
what I
yes or
did.
no, sir.
If that's what was heard on the video, yes, I did.
And at one point, you said that Officer Tao pushed you.
That's correct. He did. He put it.
Yeah, so they break away there, but all right, so you saw that, right? And the jury is now having to interpret what to make of that exchange. And there's a couple different ways that you could interpret this. You know, on the one hand, and I kind of agree with this. I think that this is a very difficult position to be in for a witness. Obviously, this is somebody who is now trying to be professional, somebody who's trying to carry himself well, to come into court, do his part in this thing. I know there are rumors around the internet that he was wearing a BLM shirt under something or other. You know, he's one of those people. It's irrelevant in my opinion. This is, all of this stuff can be discovered by the defense attorneys and they can decide what to do with it. But right now, in this case, in this situation, he's trying to present himself as a reasonable person and a witness for the government. Getting drilled with questions like this that in retrospect make you look bad is not a comfortable thing to go through. It doesn't feel good as an attorney to do that to somebody. It doesn't feel good on the receiving end, but it's a necessary thing. And so this is an uncomfortable thing that's happening right now. And so as he was answering those questions, he was actually, you could say that he's mean mugging Derek Chauvin, saying, like I'm being aggressive with you, or you could say, he's kind of being respectful. He's saying, I did say that about him, and I'm gonna make sure that he knows that I said that about him to his face. You're making eye contact. It's kind of a respectful thing to do. Yep, I said that. I'm looking at you. I'm not hiding behind it. We're gonna make eye contact and have that conversation. Whereas other people might just sort of not want to look at that person and sort of talk like they don't exist. He's at least acknowledging that he's there. I think it's a respectful thing to do. On the other hand, you can make the argument that this is not a good look for the government. This is somebody who is very hot, very volatile, somebody who's using certain language that is very provocative. And you could even use this for the defense argument to say, listen, there was somebody out there who was shouting profanity, somebody who has some training, somebody who's got a lot of experience as a mixed martial artist, somebody who's got experience as a security guard, as a wrestler, somebody who could pose an actual physical threat. This person was screaming profanities at them from the side of the road. So of course, what's the defense going to do with that? They're going to say, well, this was a dangerous situation. What did Chauvin do? He had to default back to his training, which said you never leave the scene. You don't ever let the public interfere with your investigation. And he was following the manual. This guy, by saying the things that he did, by putting him on the stand, by letting the defense attorneys call that out, they can just, sort of amplify that in their closing and say, there was a threat. There was a crowd of people, including somebody who has a deadly skill set, who is shouting profanities, calling us effing, PABs, whatever. So you can interpret this in a number of different ways. Somebody, and a lot of his other testimony was pretty compelling. We're not going to go into the prosecution's direct examination of him because a lot of it's very repetitive, but he did sort of shed some tears, right? He was emotional because he should have been emotional. Somebody died. He got to witness that, and he's responding to what he saw and knew at the moment. Now we're learning, there's new information that he didn't have at that time. And so it's easy for all of us to sort of do the hindsight is 2020 thing. But in this case, this guy is, I think he's trying to do his best, and he's doing a good job of it. And the defense attorneys are, it's a painful process, but they're just teasing out some of the relevant information. And so that was that witness. That was Mr. Williams. So he is out of the hot seat. So next witness, we have somebody who's under the age of 17. This is her. She identified herself. We have these blue blocks around here because YouTube gets weird about kids and minors. So we have her. She identified herself in this photograph, and we have her testifying. She is talking about she's 17 right now, and they're going to go through this little short clip that we have where you're going to hear her testifying. This is very emotional. She's crying. You can hear the sort of the frog in her throat as she's trying to work through this. Very emotional. And just to be clear, she's 18 now, but she was 17 back in May of 2020 when this all happened. And so just out of an abundance of caution, they are going to be making sure that they're not on camera and that their identity is somewhat protected. So this is her testifying today. And, the jury's going to hear this. They're going to see this. They're going to see a 17-year-old girl up there. And regardless of anything else, regardless of the toxicology report or the cause of death or how many, expert witnesses that both sides drag up there on the stand, jury's still going to, the government is still just imprinting these moments like an iron on your back, just scalding you, just, oh no, more pain, another 17-year-old. We have Mr. Williams, somebody who's shedding tears, all because of what? Derek Chauvin, because of Chauvin. And it's very emotional, very frothy, very effective, which is why they are doing it. So here is the 17-year-old today who is identifying Derek Chauvin in the courtroom, getting emotional while doing it.
So can you see the person depicted on Exhibit 17?
Yes.
Darnell, are you able to tell the ladies and gentlemen of the jury if you know who this man is? You can take your time.
Yes.
Please tell the ladies and gentlemen, who is this?
This was the officer that was kneeling on George Floyd's neck.
On May 25th?
Yes.
Is this the way he appeared when you saw him on May 25th, kneeling on George Floyd's neck?
Yes.
All right. So you can just hear kind of the emotion in her voice. And I wanted to sort of, move past these a little bit more quickly, but I want to show you this next clip. Same woman, same young woman who is now talking about, we're going to see this back to back. We're going to see two clips from two 17-year-olds who both testified today, and they are illustrating a theme that is part of the government's case. Specifically that Derek Chauvin put his knee harder into George Floyd's neck as the timeline progressed, as things carried forward. He actually got more aggressive. He actually adjusted his weight, lifted up his leg, and kind of dug that knee further in. And so this is a very important point here. We've been asking ourselves on this channel, doing our analysis for some time now, whether or not Derek Chauvin is going to have to get up there and explain what he was doing or why he was maintaining the hold. Okay, maintaining the hold for 9 minutes. Why? Well, after he was in handcuffs and on the ground and blacked out, why did you still have to maintain the hold? He's got to come in there and defend that. I wasn't maintaining the hold because I wanted to kill him. I was doing it because my training, my protocol, all of that said so, right? You don't abandon your scene, your investigation, because you have an externality coming in and trying to disrupt your performance. We're going to hear about this from Genevieve Hansen later, and I think in testimony that sort of backfired for the government, but that's set beside the point. Professionals don't get rattled. They don't let externalities knock them off course. That's why they're professionals. Okay. If you are a high school baseball player and somebody in the crowd says something as you're swinging the bat and you miss it, well, that's okay. You're a high school player. It's a high school game. But you're a professional athlete when that doesn't happen. In fact, you can have 50,000 screaming fans. Nobody's going to distract you. You're still going to hit that ball because you do not get rattled. That's kind of a theme that we're going to see play out here. But that is Derek Chauvin maintaining that line. The government came out with 2 witnesses today and said, oh, no, it wasn't maintaining anything. He was getting harder. It was getting worse. He was being more aggressive as time went on. When the average person would say something like, well, you would expect that as Floyd became less combative, that the use of force would you'd have an inverse relationship there. As he became less combative, or you'd have a correlated relationship there. As he became less combative, you would have less use of force. They would correlate with one another. This seems to be the inverse of that. As he became less combative, Derek Chauvin, according to these 2 witnesses, was being more aggressive. So how do they explain that now? We've got 2 witnesses who are going to be confirming that. Well, we're going to hear a little bit about it here shortly. So this is from this is from Jerry. I think this prosecutor's name is Jerry. I could be wrong about that, but Jerry Blackwell, I think, is his name. And he is asking questions of this 17-year-old. She is saying that they dug harder. Derek Chauvin dug his knee even harder into Floyd's neck.
So was there any point in your video, whether it's 9 or 10 minutes, that Mr. Chauvin ever let up or got up off of the neck of Mr. Floyd that you saw?
No, if anything, he actually was kneeling harder. Looked like he was shoving his knee in his neck. Like he was, yeah.
So was it your experience then, as the bystanders cried out, that Mr. Chauvin kneeled in even harder? Is that what you're saying?
Can you rephrase that?
You told us that it looked like Mr. Chauvin was kneeling in even harder on
Yes.
Mr. Floyd. Was there anything that was in response to that he was kneeling harder?
I feel like he was feeding off of our energy.
Calls for speculation.
I want to know.
Also, should we take our morning break at this time?
Yes, sir.
All right. Members of the jury.
All right, so very good objection there at the end, and that was Nelson saying no objection, speculation, and it calls for speculation. So that question from the prosecutor, Mr. Blackwell, was asking her to sort of opine, to speculate about whether or not Chauvin was being more aggressive with the knee as a result of some energy in the crowd. She's trying to, the prosecutor was asking her a question, asking her to read Chauvin's mind. Well, why? You said that he was putting his knee on his neck even harder. Well, why might that be? Objection. She can't know that, right? Nobody can know that. Only Chauvin would know that, and he's not on the stand. So she said there, it was objection, and the jury shouldn't be considering that. But she said something to the effect of, he was responding to the energy. Right? I mean, that's kind of that's colorful language there. He was responding to the energy, so you can see this theme start of developing from the prosecutors that Chauvin is this just monster. All right, the crowd was there yelling at him, and he's like, "I'm gonna kill him harder." That's kind of where she's going with that. So we have another 17-year-old today. Again, this is the prosecutor, who I did not catch her name, but she did some questioning here of this 17-year-old. This is a second 17-year-old, also female, who is confirming the same thing that we just heard, that Derek Chauvin, it feels like, was digging harder as time progressed. So let's listen to this one. Here she is.
Was anything about what Mr. Chauvin was doing with his body?
Yes, at one point I saw him put more and more weight onto him.
And how could you tell that?
I saw his back foot or leg lift off the ground and his hands go in his pocket.
So can you just describe a little more what you saw? You're describing the leg movement and what you're describing as a hand in the pocket. What did you see change about the way Mr. Chauvin's body position was to make you think that?
Could you repeat the question?
Sorry, it was a bad question. How did it change? How did what Mr. Chauvin was doing make it look to you like he was putting more weight on Mr. Floyd?
I kind of saw him move his knee down more,
Okay.
make little movements.
And when you say you saw Mr. Chauvin's knee move down more, what are you talking about? Down into Mr. Floyd or down somewhere else?
Down into Mr. Floyd's neck.
Okay.
All right. So interesting. Two interesting things here. Well, okay. So we just heard that, right? So she's confirming what we've already known. Another 17-year-old witness just came out, said, "Yep, knee's going in harder." This 17-year-old witness comes out, "Yep, knee was going in harder." How do we tell? Well, he sort of lifted the heel up on one of his legs. If you lift the heel up, which is picking up some of your body weight, and you're going to be adjusting that, it's got to pick, your body has to pick up the weight somewhere. So that would be the knee that, of course, is on George Floyd's neck. So got that. That theme has been established now with two different witnesses back to back. So then Eric Nelson comes out and he's asking the 17-year-old about questions, specifically about whether or not she recalls saying to investigators back in May or shortly thereafter that she observed police officers she witnessed police officers checking George Floyd's pulse multiple times. And you're going to see she doesn't remember it. No, I wouldn't have said that. I don't remember. No, that doesn't sound right. Eric Nelson, we got the document right here. They go through this whole process of sort of refreshing her memory. And that's where this clip is. Let's watch that right now, and then we'll do some discussion after the fact.
And then again, I believe just within the last 2 or 3 days, you met with the prosecution team,
Yes.
and you told them, gave them some more information as well, correct?
Yes.
All right. So, do you recall telling Agent Peterson and Ryerson, as well as the prosecution team, that while you were there, you observed the officers check Mr. Floyd's radial pulse?
I said I believe that they did. The two that were on his body, I thought at one point that I did see someone try. Nothing changed, though. Nothing with their body language or anything changed.
Okay. Do you recall, were you given an opportunity to listen to your previous statement?
No.
Were you ever given a transcript of your previous statement?
No.
Would you disagree with me if I told you you said, "I even saw them check his pulse multiple times before the ambulance got there"?
I would not agree with that.
You would not agree with that?
Yeah, because I don't remember.
You don't remember that now?
Can you restate it?
Sure. Back when you were interviewed by the police officers in September, you told them that you saw the officers check his pulse multiple times before the ambulance got there.
I do not believe I said multiple times.
May I approach the witness, Your Honor? Yeah. Date stamp 36415, page 48. I'm going to hand you this through this plexiglass, and there's some, I'm just going to point to the last underline. I'm going to ask you to read that in your mind.
So she's reading her own transcript or her own statements. Hands it back over to Mr. Nelson. He goes back up.
So did you tell Agents Ryerson and Peterson that you saw the officers check for a pulse multiple times?
Yes, I did, and then afterwards I told them that it looked like they did not find one.
Okay.
All right, so two things we can glean out of that. Number one, memory is a fickle thing. It's not something that is as permanent as people like to think. Changes all the time. Even can change if you hear and you sort of stack other memories on top of that. We all see something. That event happened. Then we hear different interpretations of that event. We saw it with our own eyes, but we hear other recounts. Somebody said that when they saw it, that happened. And somebody else said this happened. And somebody else said this also happened. And then it stacks on top of our memories. Then when we want to access our own memories, we kind of get muddled up by having to sort through all of the other memories or the other interpretations that are being muddled up in our brains. So he goes through and says, well, you said that they checked multiple times. She says, no, I didn't say that. Get out of here. Yeah, you did. Look, here's the transcript. Shows it to her. Yeah, I did say that, but right? She's sort of spring-loaded against the defense, which is just natural. You're going to see this from the defense witnesses also. When the government comes and cross-examines them, they're going to be spring-loaded to be sort of aggressive towards the government. So this is just sort of a natural thing that is happening. So credibility, not so good on some of this stuff. At least credibility about the memories. People's memories are just not very good. And so Eric Nelson, I think, was effective in sort of showing that in front of the jury. Okay, she said she saw all this stuff. She said that Chauvin was putting his knee on his neck harder, but she can't remember what she even told the investigators at that time. So how can we gauge the validity of her observations if her own memory is so bad that she can't even remember what she told the investigators herself 10 months ago? It's a credibility thing. Effective. Now, whether that lands with the jury, I don't know. But the other thing that I think is pertinent, is important, is logically it just doesn't fall into place. If Derek Chauvin wanted to kill George Floyd, or was intending that, or was doing something that was so imminently dangerous that he thought it might result in his death, why were they checking a pulse multiple times? And why did they summon an EMT, an ambulance, well before any of these witnesses showed up? It was already in route, basically, is what we've been sort of hearing from the defense. I think that's what their argument's going to be. So they're going to have to sort of insert that into the conversation. Why would they ask for an ambulance if Derek Chauvin wanted him dead? Why would they be checking for George Floyd's pulse multiple times if they wanted him dead? Logically, it just doesn't make much sense. And then our last witness that we're going to cover today is this woman. Her name is Genevieve Hansen, and she was the firefighter on the side of the road. She was not an active duty firefighter at the time, or an EMT, and so she was not in uniform when she was there on the side of the road. But she did wear a uniform to come into court today and to testify, which is, acceptable, but something worth noticing. She wasn't there as a firefighter. Typically, cops will show up in uniforms because it makes them look more credible. She looks more official than other people. Just look at her. Got a badge on there. Got a patch over here. Oh, we got 2 patches over here. Got a little lanyard and a name tag, right? It looks official. This is why people wear these outfits. This is why cops wear these outfits, because it looks official. Sort of imparts credibility. And so Mr. Nelson comments on this. He says, okay, you're in a uniform today, but you weren't on duty, right? So you weren't in a uniform when you were there, but you wore one to court today? Okay. So he kind of knows what she's doing, but he doesn't make a big deal about it. Now we're going to see that we've got 2 clips from her. She's a very interesting witness. If you're going to watch any of the witnesses today, go watch hers, because it was very tense and she's very aggressive on the stand. She's very passionate about this. And when I say aggressive, I don't mean that in a pejorative way. I mean, she's passionate, right? She was passionate that day. She was passionate on the side of the road. She saw what was happening and was passionately screaming from across the street, "Hey, check his pulse, get off of him," right? She's screaming at the officers. So it's understandable that she is upset about this, and she has a particular, perspective. That's why the government called her as a witness to come in and testify. Nothing that she's doing is necessarily wrong. It's some of it is improper for the forum. Her courtroom decorum is not well versed, but why should it be, right? She's a young firefighter, doesn't have a lot of experience with this stuff, and she's obviously upset about this. So we're going to cut her a little bit of slack on this thing. This is not, she's not a professional person who lives in the courtroom like the rest of us are. So we're going to cut her a little bit of slack on this. So that being said, I want to point this out. She gets caught in this defense reaction. When she's getting cross-examined here by Mr. Nelson, she just clams up. You're going to see this line of questioning where he's trying to get her to sort of put herself in Chauvin's shoes. He's saying, okay, listen, if you're a firefighter, right? You're an EMT, you're somebody who shows up and puts out burning buildings, douses them with water. Okay. If you're there and you're fighting a fire and people are, one person is shouting at you, does that throw you off your game? And I think she is thinking that he wants him to say yes, that he wants her to say yes. So Genevieve is thinking that Eric Nelson wants her to say, if somebody shouts at you, I will get off of Floyd, or I would do something more reasonable. And what she does is she doubles down. No, I wouldn't change anything. If somebody's yelling at me and a building's burning down, I'm so well trained, I wouldn't change a thing. You could have 10 people yelling at me. You could have 12 people screaming profanities at me. I'm not even moving a muscle. Which is exactly what Derek Chauvin did. And so I think what you're going to see here is her trying to be combative because she thinks this defense attorney is trying to paint her into a corner. And by being so stubborn, she inadvertently makes his point, probably without even realizing it. And so let's take a look at this clip. We've got this one, and then we've got one of her on the end of the day. So let's take this one first. This is Eric Nelson having a conversation with Genevieve specifically about if there were people screaming at her, whether she would be rattled or thrown off a little bit.
So you're fighting a fire, right? And you may notice a citizen filming what you're doing.
Correct.
And that would not necessarily interfere with your ability to fight a fire.
No.
Right? Have you ever had a citizen start to yell at you while you're fighting a fire?
No.
Do you think it would make your job fighting the fire harder if someone started yelling at you and telling you that you were doing it wrong?
I'm very confident in the training that I've been given, so I would not be concerned about somebody that was not trained to the extent I have been, and I would continue to fight the fire the way I would.
Right. But do you think it would be distracting?
No.
What if there were 12 people yelling at you and telling you that you were doing it wrong?
I think a burning structure in a city where there are buildings and homes and people living on either side is much more concerning than 20 people trying to tell me to do something different.
Right. But you wouldn't be distracted by that at all?
No.
What if they started calling you names?
Like I said, I know my job, and I would be confident in doing my job, and there's nothing anybody could say that would distract me.
Okay. So what if they started to physically threaten you?
I'll repeat myself because I'm confident in my job and what I do and what needs to be done and my training. So I would continue to do that.
Okay. So you sort of see what happened here, right? I think she kind of is trying to predict where where Eric Nelson was going with that line of question. He was sort of saying, well, you would, if you were Chauvin and somebody's screaming at you, wouldn't you naturally be distracted? She says, no, absolutely not. Not even if there's 20 people, not even if there's 20 people threatening to kill you. I would not be distracted, which is not the right answer, right? Obviously, anybody would be distracted. So it makes her look very unreasonable to the jury. The jury's going, what are you, whacked? Of course you'd be distracted. We'd all be distracted. If I'm sitting here, stuffing envelopes and somebody comes in and interrupts me, I'm distracted. That's a whole separate skill set than putting out a burning building or making an arrest on the side of the road. So by her just digging her heels in and saying no matter how far Eric Nelson sort of took the argument, how logically extended he dragged it out to be, she just refused to even budge. Makes her look unreasonable, makes her look not credible. So not a good look. But the other real thing that it does is it actually proves the defense point. Okay? And it undermines her own actions that day. She's saying that if she were there trying to put out a burning building and somebody came up screaming at her, she would not be flapped. She's unflappable. Nothing is going to take her off of her course. We just heard her reiterate that about 4 times. She tried to do exactly that to Chauvin. Did she not? She came right up to him screaming at him. He's trained. He's performing his duties. He's a licensed, certified officer, just like she's licensed. They both wear badges. They both have things on their shoulders. Great. She's interfering with somebody else who has more training to control a situation, presumably. We're still going to figure out whether that was the case or not. But as far as we could tell, she comes up to Chauvin, who is analogous to her standing there trying to put out a fire and having somebody come and scream at her. She's literally doing that to Chauvin. She said through her own testimony that is inappropriate. There could have been 20 of hers screaming at Chauvin, and by her own rule, by her own standard, Chauvin should not have deviated from his course because he's trained. Just like she wouldn't deviate from her course. She'd still put out the fire. Derek Chauvin, his mission is not to put out a fire. It's to conduct an arrest, to preserve the scene, to stop the public from spiraling out of control, and to preserve his life and his fellow officers' lives. So he was doing what he thought best at the time. She came up and started screaming at him. And so now she's saying that's totally inappropriate. If somebody did that to me, I would not let that deviate me from my mission. So by her digging her heels in, she just confirmed the very argument that I think the defense was trying to get out of her. This is why it's not, don't try to out clever an attorney. Just try to, ask questions or answer questions, I think, in a way that is human. Okay, she's trying to sort of fit into an argument on what her mind thinks she's supposed to be. And in reality, it just doesn't come off well unless you've really thought this through. So she gets through a lot of this back and forth. She gets into a sort of a heated argument with Eric Nelson. And so the judge, before the conclusion of her testimony, excuses the jury panel. There's a lot of back and forth going on here. We're not going to play the whole thing because it goes on for a long time. But she's very argumentative. She does not like these questions. She does not like Eric Nelson trying to sort of tease out some of her perspective. So she gets argumentative. Judge sends the jury out of the room, scolds her. Here is that clip.
Be seated. We're outside the hearing of the jury. Ms. Hansen, I'm advising you, do not argue with counsel, and specifically, do not argue with the court.
Is the camera off? Are the cameras off?
No, they are not. We are on the record.
Okay.
You will not argue with the court. You will not argue with counsel.
Mm-hmm.
They have the right to ask questions. Your job is to answer them.
I was finishing my answer.
I will determine when your answer is done.
Okay, well...
And so, do not argue with the court. Do not argue with counsel. Answer the questions. Do not volunteer information that is not requested. The attorneys for the state have redirect. They can ask you questions if they think that certain things were left out.
Okay.
It is counsel's prerogative to ask you leading questions and for you to answer those and not volunteer additional information.
Okay.
Are we clear on this?
We're clear.
Thank you. Come back tomorrow at 9:30.
All right. Night.
Do we have the...
So the judge is keeping such good control of this courtroom. And he's doing a great job. I got to be honest. He's doing a fantastic job, and he's keeping order. I was waiting until this was going to happen. Somebody was going to get a little bit ornery on the stand. Judge is going to have to sort of, nudge everybody back under control here, because if he lets that go on, then the next time a witness does something like that, and either one of the sides sort of speaks out about it, they're all going to refer back to this witness. They're going to say, well, you let her get away with it. Why are you not letting us get away with it here? So he's making sure that this line of questioning thing is sort of nipped in the bud. She gets on the stand before the end of the day. Hey, knock it off. See you back here tomorrow at 9:30. You can even hear her getting into it with him as he's scolding her. Not a good move. Judges like that are good. He was stern, but he was not too condescending. He was not condescending. He just, look, this is a different environment. This is a whole different world. People think that they may have a good argumentative personality over a debate at lunch, but when you go into the courtroom, it's a different ballgame. You got to play by the rules. It's not the layman's rules anymore. Now it's the court, and so the judge is keeping order, and he's doing, I think, a good job of it. So let's take some questions over from watchingthewatchers.locals.com. First one comes in from Spoiler. Spoiler says, Spoiler, that's easy. Hey, Spoiler, welcome to the program. Says, would you say it's pretty standard for the defense to choose not to cross-examine most of the minors, or is that a suave move by the defense? Yeah, I think it is a tactical move. It's sort of the polite thing to do, I would say. It's kind of a polite thing. Nobody likes to bring children into litigation at all. There's kind of a good question. Many people are probably asking themselves, why did the prosecution even bring those people in the first place? right? Why did they bring a 17-year-old and an 18-year-old in? And jurors don't like that. You see a high school kid crying on the stand. Well, whose fault is that, really? I mean, who dragged them into this litigation process? Well, the prosecutor did. And what information is the prosecutor, how critical is this witness? Can they make their case without a 17 or 18-year-old? Yeah, of course, because there were a ton of witnesses there. So why'd they drag them in? Because they're 17 and 18, okay? Because they look very sympathetic and they want to maximize the emotional appeal of this thing. So the prosecutor wants to bring him in. The defense attorney has nothing to gain by going out there and beating up a 17-year-old. You can't win. So what do? You don't play. You just say, all right, well, it's okay, whatever. Go ahead. No questions. I don't even know why they're here, Your Honor. They should have brought in some adults here because they have them, but they didn't. And it looks kind of petty. It looks small from a prosecution perspective, in my opinion. But I'm a defense attorney, so you would naturally believe that that would be my opinion. We have Just XUXA says, can defense recall a prosecution witness when it's the defense turn? So, I don't know what the rules are on that in this case or how they structured that. I think the judge is asking certain witness. They flesh this out early on in the case with the motions in limine, and they have some sort of rules on the recall, really the practicalities of it. How long are they going to keep witnesses around? And I just don't remember what the specifics are on that. But yeah, I mean, generally speaking, you can recall a witness if there's a new issue that's relevant, that they can come and offer some dispositive information on. If they can come back in and help you settle an issue, the court will typically allow that to happen. But if you are just going through your sort of line of questioning and you get to your third witness and you go, dang it, I forgot to ask that witness a question. Judge, hey, by the way, I really screwed this up. I need him to come in here because I can't make the rest of my arguments unless we recall them. And judge is going to go, no, it's too late. And you get one bite at the apple on this thing. And so there are specific rules about this, but I just don't know what they are in this specific case. And really the reason being is I'm not taking a deep dive into the nuts and bolts of this case unless it happens. There's a lot of stuff that we can speculate about and we can just play that game until the end of the earth. But until it really happens, well, let's just kind of wait and see what goes on. And I'm not saying that just XUXA because it's not a good question. It's a great question, but that's the reason why I don't have an answer just kind of fired off and ready to go. I'm just, there's a lot, we could play the hypothetical game all day long, and I haven't taken a deep dive into that. I'd rather just kind of see what happens. At some point, a witness will be recalled, and we'll see sort of what the judge has to say about that. Because we noticed this, if you notice this, we covered a lot of the motions in limine, sort of the rules leading up until the trial, and a lot of that stuff is not even relevant because the judge, we argued over it, but it has not even come up yet, and it may not even come up to begin with. Next up, we got Woodworking Medic says, after watching some of these clips with emotions running so high, how do attorneys contain their emotions so well? Or from your experience, do they not? They do. I think they do very well. I think it's a very, very practiced skill set. I think that you'll see newer attorneys kind of sometimes will get very emotional, very frothy. They'll get, I think the most common emotion that attorneys show is probably impatience. Not a good emotion to show either. Juries don't like that. And so you can sort of see some of that coming through with Eric Nelson. I wouldn't even say anything noticeable. I notice it because I can sort of read his facial expressions just going, oh my gosh, I have to ask this question again, a different way. Are you serious? Sort of just we're kindred spirits, right? Because we're both defense attorneys. So we just kind of get it, but it's impatience. And typically attorneys, you get enough reps with these things that you just kind of become kind of immune to it. I wouldn't say immune to it, but you do develop a poker face pretty quickly. It's kind of one of the main requirements to being an attorney, at least a litigator. Next up, we got Spoila says, how much credibility did an MMA guy and firefighter lose with the jury, if any, from their combativeness with the defense? It's a good question. And I would say some, the number's not zero, right? It's not good. If you want combativeness, if you say, well, how much combativeness am I allowed to have up there? And in the answer most of the time is zero combativeness. Now, because the judge is the person who should be combative, and your attorney should be combative for you. Okay, the prosecution should be combative. The prosecution should come back out and give you the opportunity to be rehabilitated. So let's say, for example, firefighter, right? They do a direct examination. She's a government witness. Government comes out, asks her the questions, very softball, open-ended questions, very friendly. Cross-examination comes out from the defense now. Derek Chauvin comes out. He gets to beat her up a little bit. The strategy there is not for her to be combative with Chauvin. You just got to take it. So she should have been coached a little bit better or reminded that, this is very important. Just take it. Because the prosecution gets to come back out and rehabilitate her to say, all right, so we know that blah, 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 you answered all of that. He basically gets to come and fix the problems. Because it's their witness. The defense just sort of, rattled her a little bit. Prosecution gets to come back out and rehabilitate the witness. So they get combative. They're the ones who get to fix the situation, not you. If you do it, it just looks bad in front of the jury. You look small and you lose credibility. Spoiler also says, anyone notice that the defense seems to have most of their objections sustained and the prosecution seems to have most of theirs overruled? Is this common or unique to this case so far? So I actually think that's a fair summation of this. I haven't been keeping track or keeping tabs on it, but if I can be fair about this, it sounds so. First of all, the defense is not presenting any witnesses yet. Okay, so it's the government presenting the witnesses. They're doing most of the examination. Whether they're not doing any cross examinations. They're doing the direct exam. So most of the objections are going to come from the defense. The objections that are being lodged by the prosecution against the defense are happening during the cross examination, which is a smaller part of the entire exam. It's the cross-examination can only be relevant to what comes out on the direct exam. It's not a free-for-all. So there's sort of less, there's more opportunities for the defense to object and be sustained than there are opportunities for the prosecution to object and be sustained, just due to the nature of where we're at in the trial. So I don't know that I would read anything too much into that. But I would tell you, I think that the prosecution questions haven't been as good. We saw the one, which was a very easy objection we just played here when Mr. Blackwell was asking the 17-year-old specifically about why would Derek Chauvin do something like that. It's not a good question. It's a speculative question. So yeah, objection sustained, not even a, that's a very, very rudimentary type of question. That question should have never been asked. So why was it asked? Who knows? J-Bone in the house says, should the defense push the judge to issue jury instructions as to how they should weigh causation? Obviously, the defense will have a different burden if but-for standard is used with regards to the cause of death. So good question there, J-Bone. And you know what I did? Actually, I was looking up this issue last night. I was reading through the Noor, N-O-O-R case. They have their jury instructions published from that trial. I think it's the 3 same exact charges that Chauvin is facing in this case. So if you want to see what the jury's going to get, go look at those. Just type in Noor jury instructions and read those. That'll answer your question. That will show you the packet, very similar to what I think they're going to get in this case. That happened a year ago. Not much is going to change. Now, the facts are going to change, so you can't obviously, it's a whole different set of facts, but it is something that is available on the internet. You can pick that up and just read through it. Nadar Blasier says, does the judge or anyone else instruct the jurors to look out for things like memory, honesty, hypocrisy, etc. in witnesses throughout the trial? So not throughout the trial, typically, but the judge did give them sort of an admonition and instructions at the very start of the trial and explain this. You got to keep track of all this stuff because we're not going to give you a transcript. You're not going to be able to go and sort of do a rewind the game tape. Take notes in your journal, and you get to be the judge of credibility of the witnesses. But it's not typical that you see them, hey, the judge isn't going to nudge the jury after somebody leaves a witness stand and say, hey, by the way, you're supposed to be, gauging a witness's credibility. Since that person just got off the stand, maybe just, write that down in your notebook. And he's not going to sort of ring the bell for them again. They know what they're supposed to do. It's their obligation to do it. News Now Wyoming says, I was thinking the EMT was the greatest witness yet. It was appropriately emotional. Then she got testy with the defense, and I just hope she doesn't lose credibility with the jurors. Yeah, she did get testy. She was very emotional, and I agree. She did get testy with the defense. And you could even make the argument that jurors like that, right? Jurors say, she knows what she saw. She was there. We don't. I'm already seeing a lot of this on Twitter. Actually, a lot of people are saying, why are we even having a trial? We saw what we saw. We know what happened here. which is kind of an insane thing to say. We don't need trials anymore. We can just convict people on Twitter, apparently. But the point here is, yeah, it's pushing back, right? If you have jurors who are already predisposed to thinking one way, which many of them are, as we can sort of speculate on just based on some of the questions that we heard during voir dire, maybe they like that. Yeah, push back, get him, right? You know what you saw. You're an EMT. Don't let him rattle you. Now, the jury's not going to see the judge scolding, nor should they, because then they would just dismiss all of her testimony. But we'll see maybe tomorrow if her attitude changes. Osak71 says, Rob, big fan. Question, how hard is cross? And also, would it be a good idea to have both male and female lawyers on your team for questions? Do you stay with only one, with one only asking questions? Good questions. So cross-examination, I think is, I don't know, one of the more fun aspects of a trial because you really get to dig a little bit. And I don't think that it's necessarily hard as long as you sort of do your research. I think if you're very familiar with your case, you know what direction you want to go and what themes you want to hit. And then you're just kind of playing around with the witness on the stand. I mean, to use a, not really an appropriate term, but that's kind of what it is. It's kind of fun a little bit. And what you can typically do, you'll see attorneys do this, is they'll just sort of draw out two lines of questions, or you'll have different forks. So you say, okay, I'm going to ask this question if I'm going to ask this person. So is it A, B, or C? And they say, it's A. Okay, well, if they say A, then you go down that line of question. And if it's A, then is it A1 or A2 or A3? And you got those different branches. So you just kind of go down the thing. Now, if they go from an A question, or they give you a B, they follow that up with a B2, you got a B27, whatever, right? And you've got your sort of line of questioning, and you can sort of, fork out where your question is going to go, and then you sort of want them all to go back to the same conclusion. You want to steer that argument into what you want to get out of that witness. And look, not every witness is there to answer the cause of death question. Some of them are there to sort of lay foundation or to give an impression or to set an emotional tone. And so you got to respond to those witnesses in that manner. As to your next question about male and female lawyers, yeah, it's a great strategy. And yeah, typically only one person will do cross-examination. They'll complete the entire cross-examination because it's kind of weird to have attorneys standing up and sitting down and having multiple people ask questions. It just doesn't work out well. You want to sort of connect the questions to one another. You're stringing them together to cipher through other attorneys is not really ideal. But yeah, you do have male, female attorneys. You see what the government is doing. They have an African-American attorney who did the opening arguments and did some of the direct examinations of witnesses today. You'll see that in sexual assault trials, sometimes you want, if the defendant is a male, you'll want a female lawyer who comes in because it's much easier. It's much more palatable to have a female up there saying that another female who is the alleged victim is a liar than it is a man saying that, right? It's just kind of the way people work. So you think about those things. How can we make the jury empathize and connect with and relate with the person who's doing the presentation? Gender, sex, age, suit and tie, look, right? Voice. Sometimes a voice will kill an attorney. There's a lot of different permutations that go into the whole thing. But yeah, gender and all of that stuff is relevant. Liberty or Death says, you would think with so many prosecutors, the state would have assigned one to prepare the witnesses better. Yeah, you would think that. They were pretty combative. I'm not sure how that sort of slipped through the cracks. Maybe they want that. I don't know. We got News Now Wyoming says, do defense attorneys typically get access to witnesses before a criminal trial like they do in civil, or do they only get access to the documents? Yeah, so we get to do interviews with witnesses. Really, the only things that are really off limits to us as defense lawyers are victims. Very difficult for us to go and interview the victim of a crime because at least in Arizona, we have what's called a Victim's Bill of Rights, which is a pretty important document that basically says they are in a special class of people that get certain rights that defense attorneys can't, we can't demand that they comply with interviews and things like that in a lot of cases. So, but everything else is fair game. Witnesses, documents, most of that stuff. If there's a battle over any of that, we hash that out in court during our pretrial conferences where we fight over discovery. So I'm sure they have a lot of access to that stuff. Now, whether they did, witness interviews of any of these people is a whole separate ballgame. We just don't know.